Good morning everyone. I am Apeksha, Assistant Professor in Indra Plus Law College. So today we are going to start with this is the second lecture on judicial activism. We'll do about public interest litigation. So for a quick revision, I'll tell you what judicial activism is and what did we study in our previous lecture. Now judicial activism is it reflects the active role played by the judiciary in promoting justice. So it is basically a kind of judicial ruling centered upon personal or political interest. And according to Black Law Dictionary, it also tends to explain judicial activism as a philosophy of judicial decision making whereby judges allow their personal views about public policy among other factors to guide their decision. Right? Now what is PIL? See, public interest litigation. This expression, it has been borrowed from American jurisprudence where it was designed to provide the legal representation to previously underrepresented groups like the poor, the racial, minorities, unorganized consumer, citizens, whoever were passionate about environmental issues or any other, etc. So, before going on to PIL, let's revise about judicial activism. Then Justice Krishna Iyer, he gave a remark that every judge is an activist either on their forward gear or on the reverse. So these are some important things which we have already done about judicial activism, and this is all about it. Now starting with public interest litigation. What is it? So public interest litigation means litigation filed in a court of law for the protection of public interests such as pollution, terrorism, road safety, construction hazard, etc. And any matter where the interest of public at large is affected can be redressed by filing a public interest litigation in a court of law. So public interest litigation is not defined in any statute or in any act. It has been interpreted by judges to consider the intention of public at large. So hope you understand. Now the very important part of it is locus standi. What is locus standi? It means the ability of a party to demonstrate to the court sufficient connection to and harm from the law or action challenged to support that party's participation. Which means in PIL, without locus standi also you can go without locus standi, you can't go to court for relief. But in case of PIL, it is relaxed. Even you don't have locus standi, that is, you are, as it states, placed to stand, which means the ability of a party to demonstrate to the court. If I am able, as a party, to go to the court, if my rights are being infringed, right, and if I am able for a part, the one who is capable as a party to go to the court or demonstrate to the court, which have the connection to and harm from law or action challenged to support that party's participation, in case that is said as locus standi. Now, what in case of public interest litigation? In case of PIL, it is relaxed. So, firstly, without locus standi, you cannot go to court for any kind of relief. You need to have the locus standi. That is, which means, what is locus standi? The ability of a party to demonstrate to the court, to stand, to demonstrate to the court. So for that, to get any relief from court, you need to have locus standi. But in case of public interest litigation, it is relaxed. So therefore, PIL became a strong weapon to raise the voice of weaker section of the society in Supreme Court. Right. Now, public interest litigation is not defined in any statute or in any act. It has been interpreted by judges to consider the intention of public at large. Now, public interest litigation is the power given to the public by courts through judicial activism. However, the person filing the petition must prove to the satisfaction of the court that petition is being filed for a public interest and not just as a frivolous litigation, right? So the court can itself take cognizance of the matter and proceed suo motu, that is, they can itself take the cognizance of any matter, or on the petition which is filed by any or any petition of any public spirited individual. Now, there are some matters which are entertained under PIL: bonded labor matter, neglected children's, non-payment of minimum wages to worker, exploitation of casual worker, atrocities on women, on environmental pollutions. We have many cases, we will deal with it, we will understand it. See, this Article 21 in Judicial Activism, as it says, no person shall be deprived of his life of personal liberty. This is Article 21. In A.K. Gopalan versus State of Madras, Supreme Court rejected the argument to deprive a person of his life or liberty, not only the procedures prescribed by law for doing so must be followed, but that procedure should also be fair, reasonable and just. So there was this interpretation. See, judicial activism, either it is done by a PIL or by interpreting the fundamental rights or by interpretation of the constitution. So in these two ways we do the judicial activism. It is done by the judges. Then this important case of Husnaira Khatun versus State of Bihar is another case where a series of articles were published in Indian Express which exposed the plight of under trial prisoner in State of Bihar, right? And and they're under trial. Many of them had been in jail for longer period. So the Supreme Court accepted the locus standi of advocate to maintain the writ petition and gave direction through which the right to speedy trial was highlighted from Husnaira Khatun versus State of Bihar. Alright, again in Pramanand Katara versus Union of India, it was about medical legal case. What happened in this? The court held that no medical authority could refuse to provide immediate medical attention to a patient in need in any emergency case. So the PIL had a reason because many hospitals were refusing to admit patients in medical legal cases. Therefore, Supreme Court ruled that access to healthcare is a justifiable right. Then in Sunil Batra versus Delhi administration, it was about it led to jail reforms. These were some cases on environment pollution, like Taj Mahal case, where in MC Mehta versus Union of India, the Apex Court gave various directions, including banning the use of coal and coke and directing the industries to switch over the CNG. So again, it was on environment pollution. Then Ganga pollution case, vehicular pollution case, oil and gas leak case. This is a landmark judgment in which the principle of absolute liability was laid down. Delhi sewage treatment plant. So this is how PIL comes into effect and how it plays a important, how it is very important for for judicial activism. Child labor case, Kamal Nath case. These are real leading cases. Like in Kamal Nath, Supreme Court recognized polluter pays principle and public trust doctrines. Then groundwater pollution case, right? Now there are some problems also. There is some misuse of PIL. There are so many frivolous PILs being filed for frivolous issues. It is being filed, and there is a highly misuse and overuse of it. It is also being used for political benefit, for personal gains. But then again, this is really important. PIL is an extreme important tool. Right? Then, so I hope you understood about it. In PIL, initially it was sown in India by Justice Krishna Iyer in 1976 in the case of Mumbai Kamanagar Sabha versus Abdul Thai. And the first reported case was this one, which I just told you, Husnaira Khatun versus State of Bihar in 1979, which focused on inhuman condition of prisons and under the trial prisoners. That led to the release of around 40,000 under trial prisoners were released. So these many prisoners were released in this case, and it gave a direction of right to speedy trial. This was highlighted in Husnaira Khatun versus State of Bihar, which was the first case, reported case of PIL in India. Then a new era of PIL movement was there by Justice P.N. It started from Justice P.N. Bhagwati in the case of S.P. Gupta versus Union of India. Now in this case it was held, this S.P. Gupta versus Union of India. In this case it was held that any member of the public or social action group acting bona fide can invoke the writ jurisdiction of the High Court, that is under 226 of the Supreme Court or the Supreme Court under 32, seeking redressal against violation of legal or constitutional rights of person who due to social or economic or any other disability cannot approach the court. So it just told that any member of public or any social action group acting bona fide, they can invoke the writ jurisdiction of the High Court and Supreme Court. So they can invoke the writ jurisdiction under 226 in High Court and in Supreme Court for seeking redressal against violation of any legal or constitutional right of any person who due to social or economic or any other disability they cannot approach the court. So any member of the public or social action group can invoke that writ petition. It was held under S.P. Gupta versus Union of India. So by this judgment, what we understood? By this judgment, PIL became a important weapon for the enforcement of the public duties, where executive action or misdeed resulted in public injury. So now what happened was that any citizen of India or any consumer group or any social action group can directly approach this apex court of the country for seeking the legal remedy in all the cases where the interest of general public or a section of public at large were at stake. So any citizen could directly go to the apex court. Then Justice Bhagwati, they did a lot to ensure that concept of PIL was clearly initiated. Right? So Supreme Court, then other cases were also there. In Indian Banks Association Bombay and others versus Devkala Consultancy Service, it was held that a private interest case can also be treated as a public interest case. Then other cases, as I told you, Pramanand Katara was there. MC Mehta versus Union of India. It was a PIL which was brought against Ganga water pollution to prevent any further pollution of Ganga water. It is given here, Ganga pollution case. We call it a Ganga pollution case. So Supreme Court held that petitioner, although is not a owner, is entitled to move the court for enforcement of any statutory provision, as he is the person which is interested in protecting the lives of people who make use of Ganga water. Right? So then in Vishakha versus State of Rajasthan, again judgment of case recognized the sexual harassment as a violation of fundamental constitutional right. Which constitutional rights were it was violative of Article 14 of equality, 15 and 21. The guidelines also directed for sexual harassment of women at workplace, Prevention, Prohibition and Redressal Act of 2013 came into effect due to its guideline. So these are some things of some effects, some cases related to as a result of public interest litigation and how some guidelines came and changed things and were into public favor in public interest. Now if I tell you what are the factors responsible for the growth of PIL in India, the character of us is that the character of Indian constitution, if we see, India has a written constitution. And under Part 3, from fundamental right to DPSP, they provide a framework for regulating the relation between a state and a citizen and between citizens. So India has become the most progressive social legislation So, to be found anywhere in the world, where it be relating to bonded labor, minimum wages, environmental protection, etc. So this has made it easier for the courts to call up the executive when they are not performing their duties to ensure the rights of the poor are protected as per the law of the land. And then again, the liberal interpretation of locus standi, that you in the PIL case it is relaxed, where any person can apply to the court on behalf of those who are economically, physically are unable to come before. So any person can on their behalf can file. Then judges themselves have in some cases initiated the suo moto action based, which are based on newspaper articles or letters which they receive. So they also initiate the suo moto, that is they themselves take into their cognizance. Then there are judicial innovations to help the poor and marginalized. So who can file a PIL and against whom? Any citizen can file a PIL, public case, by filing a petition under Article 32 in the Supreme Court, under 226 in the High Court, and under 133 of CRPC in the Court of Magistrate. So these are the things, PIL and against whom it can be filed. However, but the court must be satisfied that the writ petition fulfills some basic needs for PIL, as the letter is addressed by the aggrieved person, public spirited individual, and a social action group for the enforcement of the legal or constitutional right to any person who are not able to approach the court for redress. And a PIL can be filed against the state, central government, municipal authorities, and not only any and not to any private party, but to all of these. So the aim of PIL is to give to the common people access to the court to obtain the legal redress. PIL is an important tool of this social change for maintaining the rule of law, for further accelerating the balance between the law and justice. So the very original purpose of PIL has been to make justice accessible to the poor and the marginalized. This is the very basic original purpose of a PIL. And it is an important tool to make human rights reach to those who have been denied the rights. So it democratizes the access of justice to all. And it also helps in judicial monitoring of state institutions like the prisons, asylum, protective homes, etc. and so on. So there are, as I said, that there are some, these all are the cases, then there are some problems of PIL, and then there is some these weaknesses are like, it could lead to overburdening of courts with the frivolous PIL which by the parties. So in PIL today, it has been appropriated for corporate, political and personal gains. It is no more limited to problems of the poor and the oppressed only, but for these things. And then the cases of judicial overreach by the judiciary is in the process of solving the socio-economic or the environmental problems can take place through these PIL. Then PIL matters concerning the exploited and disadvantaged group are pending for many years. So inordinate delays are also there in disposing of the PIL cases. So these are certain problems, but if we conclude it, then PIL, the greatest contribution of PIL has been to enhance the accountability of the government towards the human rights of the poor. We can conclude it in this way. So PIL is an important part. In further lecture, we will do with the other rules of the interpretation. Thank you.